Hello, everyone. My name is Fallon Speaker, and I am a professor and a director of the Jeanette Littman Family Law Clinic at the University of Richmond School of Law. I'm excited to be here with you today to discuss a presentation that I feel is very timely given a lot of the recent and current legislation passed in Virginia and all of the work that is being done as it relates to substance use and specifically marijuana use policy. So the title of my presentation is called The War on Drugs and Rise of DSS, Exploring the Lingering Impact on Family Unity and Parental Rights. I'd just like to give a brief disclaimer. This is not legal advice in any way, shape, form, or fashion. Although I am a licensed attorney, if you do have any questions about any of the issues or topics that I raise in this presentation, my contact information will be provided at the end, and you can feel free to reach out to me to discuss. And in general, if you have any questions regarding any sort of legal case that you have, you can reach out to the Family Law Clinic or to any other attorney for actual legal advice. So here are some key terms that I would like to just start us off with to ground us in some of the things that we're going to be discussing. First is going to be substance use disorder, generally defined as a disease that affects the person's brain and behavior and leads to inability to control the use of a legal or illegal drug or medication. DSS, the Department of Social Services. This is generally a local and state office that oversees child protection and welfare related services. As you'll see, we'll start referring to child welfare system and the CPS, Child Protective Services, as family regulation system later on in our presentation. CPS is workers employed by DSS to supervise and investigate child protective cases. And then the child welfare system is generally discussing the whole system as a whole: DSS, CPS, foster care agencies, courts, and providers. So a brief roadmap of where we're going to go at today. First, we'll start with a historical context of policing and surveillance. We'll move on to talk about the war on Black communities, also known as the war on drugs, picking up allies, how the child welfare system joined the war, and then impact that joining had in terms of prioritizing family separation over reunification efforts. And then we'll also discuss sort of the criminal legislation and policy changes that have happened and whether or not those outcomes have improved outcomes in civil family regulation. Lastly, we'll finish with where do we go from here. I'll offer some ideas and insight into possible solutions and ways in which that we could, as advocates, attack this issue. So, in this session, we're going to be discussing how the war on drugs has impacted parental rights through the use of the child welfare system. First, we're going to start with the historical context of policing and surveillance. To begin the presentation, we need to start with policing and surveillance because we need to define the terms policing and surveillance, understand the historical criminal context, and how that context sort of transcended into the civil child welfare and family regulation system. So, with our brief history of policing, I'm going to move through this pretty quickly because it's not the meat of our presentation. But we know that policing started historically in the 1600s with the night watch over white colonists, and then it increased in the 1700s to patrol groups to catch runaway slaves. The reason why this is important because the system of child welfare regulation and criminal policing is rooted and grounded in slavery. And so this is just showing you sort of the idea of policing used to protect whiteness, white colonies, white property, and is largely impacted against Black and brown bodies from the very onset of the idea and thought process behind policing. In the 1800s, policing rose to increase in this end of the slave patrol and rise of the Ku Klux Klan and their formal police forces. What we know during this period of time is that with the establishment of the Ku Klux Klan infiltrated every aspect of the legal system as we know it today, from judges to police officers to all court personnel, to people who were allowed to create law, legislators, and people who were allowed to enforce the law, right? In the 1900s, we see the establishment of formal police stations nationwide. And then we also see the rise of surveillance during this period of time. And this was led largely by August Vollmer. He's known as the father of modern policing. We're talking about now foot patrols of neighborhoods. And one of the things that he did was think about how do we incorporate psychology, sociology, and social work into policing. And then this is sort of distinguishing between juvenile and adult crime variation. The reason why that is important because also during this period of time, there was a rise in prohibition, and then largely organized crime. And J. Edgar Hoover doubled down during this period of time, even though this was predominantly white involved crime, to increase surveillance and policing. What we saw was a change in focus from science focused surveillance and policing, right? So thinking about sort of the reasons for why people commit crimes, to sort of really doubling down on getting people who commit crimes off the street, right? Fighting street crime. Um, the reason why this is important is, though, even though this started with largely white dominated sorts of crime, this sort of on the ground street surveillance and patrolling of communities really doubled down with patrol over the Black community in the 1960s. And policing and surveillance. What we know during that period of time is that in the early 1900s through the 1960s, we had the onset of the Jim Crow laws. This was legislation that was passed and existed approximately 100 years post-Civil War. What we know about this legislation is that it was a collection of local and state statutes that legalized segregation. It authorized criminal punishment against Black and brown people for breaking statutes that were put in place to separate and protect, again, white communities and white property. This led to increased surveillance of Black communities, and violations often were very substantive, including incarceration for long periods of time, violence and assault on Black and brown bodies, and then ultimately death. So we know that the folks living in Black communities started to fight back. They started to push back. There were a large-scale protests nationally. We have this onset of the Civil Rights Movement, which ultimately led to a lot of positive legislation for Black communities. But this did not end the terrorization of Black and brown communities as it relates to policing and surveillance. In fact, it actually increased their surveillance in these communities. And what we know during this period of time, and what's worth noting, is that this is where we're going to see the start of the war on drugs. And I like to talk about this as also sort of the war on Black communities, right? We talk about the war on drugs, but I think we have to read Black and brown communities when we're referring to that, because what we know now is that we also are living in a modern substance epidemic, right? The opioid epidemic, and that way in which that epidemic is being handled as a modern medical and public health crisis, as opposed to a war on drugs, is systemically different. And the way that we are able to see that is largely in the target group of people, Black and brown bodies, in the 60s through the 90s and 2000s, and then largely mostly white and poor communities as it relates to the opioid epidemic today. So just a brief overview, because I know you all have thoroughly talked about this in other sessions, but looking at the war on drugs, what we know is that this was coined in 1971. Largely what this did was increase the size and presence of federal drug control agencies in Black and brown communities. It allowed for an increase in legislation to allow for more surveillance and policing. So some of the things that we are very popular that we know about during this period of time are the introduction of no-knock warrants. Again, I want us to come back to this in a little bit, because what we know is that there are going to be a lot of parallels in terms of how policing evolved during the war on drugs from the criminal context, and I want to think about these parallels as it relates to the civil context. So one thing is here is that we see there's no knock warrants. There's these different pieces of legislation that is put in place for surveillance and sort of infringing on people's rights in their communities, and largely we saw this in Black and brown communities. This ramped up in the 1980s with increased arrests and surveillance and convictions in communities of color, and what we know led to what we know now as mass incarceration of Black and brown men, and also women, right? There is not enough conversation that happens with regards to how this implosion also impacted women. So there were high rates of women who were incarcerated, and not only that, what we found during this period of time, and hindsight, is being able to look back and see that there was an implosion as well in the foster care system. Based on this implosion in the 1980s, and incarceration rate. There was a violent crime bill passed in 1994. This provided grants to law enforcement to increase their presence in Black and Brown communities, build new prisons, push for cooperation between police and state agencies, and to increase efforts in terms of surveying Black and Brown communities. And so when I say state agencies, what I'm referring to is child welfare or Department of Social Service agencies, low-income housing and public assistance agencies, schools, medical facilities that are, given grants and funding by the government. What we're talking about is sort of a idea that we can expand our reach and surveillance if we have different people who are able to report to us and link us to possible presence of crime in the community. The last piece I will speak on here as it relates to the war on drugs during this period of time is that I mentioned there was an increase in Black and Brown women who were incarcerated. Sometimes that was for in relation to the sale of a narcotic, but oftentimes that was because of use, right? So women who were found to be positive or test positive as they were given birth, or women who were labeled as crack addicts and welfare queens. This was largely when this terminology came into place. And then poor Black and Brown women were given these labels and then stigmatized largely. Lots of at-risk profiles created for them in many of the areas that were and agencies that were created to provide them with protection and assistance. So think hospitals, think low-income medical clinics, pediatric centers, substance use and treatment programs, and think public assistance and community resource organizations, right? Right. So then let's talk about how does this sort of historical context of policing and surveillance in poor communities transcend to the family regulation agencies that we referred to earlier, largely the Department of Social Services and Child Welfare System. So first, we want to think about sort of what the child welfare system is. We gave a short definition of that earlier in terms of the combination of different systems and providers who are in place for the protection of children. But largely, I want to think about some of the legislation that was enacted and what the intent was in that in enacting that legislation, right? So state intervention into the rearing of children happened early on. We know that from what I just discussed relating to slavery, right? There was the ripping away of Black and Brown children since Black and Brown people have been on sort of, I guess, policed by the systems that have been in play in this country, right? And so what we know is that early on, child welfare was initiated in the early 1900s in an effort to achieve financial support for poor white families, specifically widows or single white parents. And in fact, Black and Brown people were excluded from being able to receive the same sort of aid in which white women were in the early legislation in the early 1900s. I think 1900s and 1930s, 40s. What we know is that with the increase in funding that was allowed to be used for child welfare purposes, so foster care, adoption, other sort of child welfare subsidies, came that, and like I said, talked about the civil rights movement, right? The need to open up this funding and explore other communities, so read communities of color. In 1974, we had the Child Abuse Prevention and Treatment Act, commonly referred to as CAPTA. This provided funds to states to provide and increase surveillance for the prevention, detection, and investigation of child maltreatment, neglect, and abuse. And this is important because CAPTA funds are still provided today, but largely what this did was increase the number of agencies who would be able to apply for this funding, so long as they were able to show that they were putting into place measures for this sort of surveillance and protection of children. Now, in 1980, we had the Adoption Assistance and Child Welfare Act passed, and this program was actually, I think, very sort of before its time, and really thinking about the state of where we're at with the child welfare system today. Because largely early on, this program was created and tailored to invest in reunification, right? The strategy and the reasoning behind this was because up until this point in time, what was realized is that in certain communities, brown and black communities, there was a high rate of removal and also termination of rights. And so this program was tailored towards reunification, divesting funds from state uh, state programs and investing those funds back into the community, right? So we wanted to reduce the cost of out of home placements and invest those funds into the community, into programs, into preventative resources. And that's important. We're going to come back to that later on in the presentation. But what we know is, if you're looking at the parallel between what happened in this idea in 1980 to what happened with child welfare from 1980 to 1997, what we know is the large catalyst and the change in focusing on reunification, focusing on keeping families together, as opposed to family separation and foster care and adoption, was largely the war on drugs. So, because this narrative was created via the mass incarceration of Black men and women, thinking about welfare queens and crack babies, what we have is this, like I said, this explosion in terms of children who are now in the foster care system, right? And largely what happened early on was like, what are we going to do? Right. We know that there was a concern created during this period of time, and a narrative that was created in terms of the people who were appearing, the children who were appearing in court, the children who were seen to be testing positive, suffering from withdrawal symptoms. There are a number of YouTube videos and old articles that you could research and review relating to sort of the harms, the developmental, the psychological, the physical harms that children were suffering as a result of being exposed to substance use during pregnancy. And then also the harms that those children suffered as a result of being with their parents who were continuing to use substances afterwards, right? So I just want to be clear that I don't think this was this sort of uprise and angst was just related to DSS and GALs, guardian ad litem, people who represent children in courts in terms of their concern. I think this was a concern that eventually became shared by the community based on the narrative that was put out, that the harm was resulting from substance use, right? And so I say that to say that, there's a lot of information now that supports the fact that communities in general wanted to find the answer to this. And what we're talking about is, what is the harm? Why are people concerned with substance use, and why is family regulation needed? And a lot of that harm is seen to come from the fact that, or the belief that people who are using substances have a physical or mental impairment. They have a reduced capacity to respond to their child's needs. Largely inability to regulate their own emotions, but also the emotions of the child, which could lead to some physical or excessive corporal punishment. And then also lack of supervision, right? Inability to properly supervise the child, sometimes leaving the child home alone or with family members or other people who aren't going to be able to provide the best protective capacity. And so while we know that substance use now can be very different for every person, this created a zero tolerance policy as it related to substance use. And so now what we see is that families were subjected to punishment, not only through the criminal system, but also through the civil system, right? So you could be penalized for substance use or sale of narcotics, but also you could be penalized in terms of having your child removed, and then potentially your rights terminated based off of this as well. So some key factors that the court is going to look at and try to consider during this period of time is, was the parent left alone? Was there any sort of drug sale or trafficking? And then thinking about the impact of the substance use on the child. Was the substance within the purview of the child? Could the child grab the substance, use the substance? Was the child able to, inject the substance into themselves? Toxicology, was the child tested positive or born with any sort of withdrawal symptoms? This became codified in state codes as abuse and neglect, sort of. And what we're thinking about here is the parent or caretaker using drugs to the point of not being able to adequately care for the child, keeping, manufacturing, or selling drugs in the presence of a child, or giving drugs to a child. And then what we know becomes very problematic about this codification is that in many cases, it was oftentimes, which is often the case in general when we're talking about the law and Black and brown families, is that it was oftentimes applied in a disparate way, right? And so what we know, and we're going to get into some of this data in a second, is that it allowed room for explicit and implicit biases in terms of how the investigation would unfold, and then what sort of services and punitive measures would be taken based on the investigation and what was discovered during the investigation. So it also opened the door. So maybe, it was some substance related issue that really didn't affect the safety of the child, but it opened the door during the investigation to other issues that could give rise to a removal of the child from the home, such as mental health, homelessness, education, domestic violence, corporal punishment, those types of issues. So what we know is that based on this period, this, I guess, 15 to 20 year period of time, with the ramp up and explosion in foster care cases and incarceration of women and men through the criminal system, there was need from the state's perspective to provide more services and increase funding for foster care, for Department of Social Services oversight, surveillance, and policing, as opposed to more money into prevention and reunification programs. And so we see the switch happen with the Adoption and Safe Families Act in 1997. This policy is tailored towards boosting foster care and the speed of adoption. That's the short of it. It created a permanent placement option for children in care. It created this sort of rule that, you have 15 out of 22 months to really work on reunifying and completing whatever service plan is put in place for you to reunify with your child if your child is removed and placed with a relative or in foster care. And then if you fail to do that, state courts could order, or agencies could be required to file a petition to terminate your rights. This sped up the process for termination and allowed for what many saw as a positive thing to open up space for children to be adopted, right? If we can speed up the process and not have these kids linger in foster care, we can, in effect, provide more permanent options for children. That was the thought. It codified the neglect and abuse standards for reunification and provided incentives for adoption. It increased a lot of funding for surveillance and welfare programs, and specifically for providing and increasing mandated reporter laws. So really briefly, I just want to talk about what is mandated reporting for those of you who don't know. Well, this is our equivalent to policing in the child regulation system. So mandated reporters are required oftentimes in every state. Sometimes these can be people who are licensed or who work with children specifically. And then there are some states who make the law make everyone in the state a mandated reporter, right? So generally it's a set of laws and rules that require people to make a report if they suspect a child has been maltreated, abused, or neglected. Mandated reporters can be anyone, like I said, who might have the opportunity to work with children, social workers, public school officials, Medicaid treatment providers, hospital staff, daycare providers, bus drivers, EMT workers, therapists, clinicians, police officers, people who work in low-income housing, generally people who receive a lot of funding from the government. Anyone who can have access to a child can largely be someone who's required a mandate report. And like I said, some state statutes require everyone to report. The reason why this is important is because you can be charged with a misdemeanor if you fail to report. And so what this leads to is an over-reporting epidemic, right? And largely we see that the over-reporting is going to occur in communities of color. Marginalized communities, low-income communities. So what we know is that people tend to over-report out of a fear of, one, losing their job, two, being charged with whatever criminal code is attached to failing to report. And there's an assumption that if we increase reporting, then we have better outcomes, but that is not what the studies show. The studies show that there's a disproportionate number of Black and brown families who are reported on because they come into contact with mandated reporters more often. largely they're also going to be highly reported on based on the different screening factors that are put into place to report. And we know that these screening factors are at every stage. These will be what we consider the high risk of reports, right? So like any sort of checklist that lists ask someone to check when you go to the doctor, for example, or do you and your family have enough food, or have you ever been a victim of assault, have you ever used a substance, do you live in this type of community, do you live in a single parent household, those sorts of questions, right, are establishing what we call risk, presumptive risk, right? These presumptive risk assessments do not further indicate the likelihood of actual maltreatment or neglect or abuse, but largely increase the number of calls that are made presumptively assuming that that risk of abuse or neglect may be happening. And so this is just an example of a code. This is actually Virginia's code, passcode. And so it talks about all the different types of people who are required to report. And these sort of codes can be found in any state. So now I just want to talk briefly about sort of the impact of promoting family separation versus prioritizing reunification. We're going to talk about the harm caused. So when you're looking at the effect of mass policing and surveillance, you have to really just think about the disproportionate outcomes, right? The disproportionate outcomes are oftentimes highlighted when we're talking about this from a criminal perspective, but not so much when we're talking about the impact that the collateral consequences from the criminal case or just the observation and policing of substances in general can have on families, and specifically the target that is on Black and brown families and poor communities, and specifically as it relates to the child welfare system, right? And Dr. Roberts says this very eloquently: it's a system designed to regulate, monitor, and punish poor families, especially poor Black families. This is why we know this to be true. When we look at the numbers, there are roughly 438,000 children in foster care nationally, and we know that Black children make up 13.8% of the population, but are 23% of the children in foster care. And as of October 2020, and then specifically looking at the state of Virginia, there were 5,374 children in foster care, and then 28.1% of those children were Black. Just to be very clear, Black children are 20% of the child population in Virginia. And I also just wanted to show you this data here when we're talking about the actual harm, right? So we're looking at prevalence of parental alcohol or drug abuse identified as a condition for removal. And this is looking at the United States in total. And what we see here is the national data suggests that there's about 38.9% of cases in which alcohol or substance use was considered to be a factor in the removal in year 2019, right? And you can see a very steady incline and increase in these numbers, right? So just looking at this data, in 2019 in the state of Virginia, compared to the national average, Virginia also reported that 31 to 40% of all removals were linked to substance use, and then 40 to 50% of those removals happened in children who were under age 1. Why is that the case? Well, I spoke earlier about mandated reporters, and I just want to spend a couple of minutes talking specifically about how this sort of surveillance extends beyond what we know as the typical type of surveillance system, which may be the child welfare system, but how the reach of the child welfare system is extended by way of mandated reporters. And this is a great case example thinking about perinatal and postpartum surveillance in hospitals. And what we're talking about specifically here is the non-consensual testing of pregnant Black and brown women. I'm going to use pregnant Black and brown women as our focal group because that is primarily the group of people who are tested without consent, including also poor women, right? Studies suggest that Black women are more likely than white women to be drug tested before or immediately following childbirth, despite similar rates of drug use, and that they are more likely to be deemed unfit parents, lose custody of their children. There has been calls nationally, and I was a part of a large part of this movement in the state of New York, and specifically in New York City, to address substance use disorder as a public health matter, not a moral matter. What I saw in my time representing parents there, and actually this happened while I was cross-examining a CPS worker on the stand. When I asked why my client was tested after giving birth, I was told that it's actually policy. It was policy at that time for CPS workers to ask social workers in the hospital to did they test a parent. And I asked, was that all parents? And they said specifically at this hospital they asked for it. It happened to be a hospital in the South Bronx. The data, if you look up the data from New York, and there's a lot of it on it, thanks to the number of defender organizations and nonprofits there who've done the research and really fought and got legislation to help pregnant women and those who've given birth to fight back against this, right? But the data suggested that this was largely happening at hospitals in low-income communities and among Black and Brown people. And this is not just in the city of New York. This is also in every state. And like I said, there's a lot of reasons for that. Sometimes it's the risk factor analysis that are given, and then oftentimes it's just the implicit and explicit biases that exist in these hospitals. But what is more worse than the fact that these women are tested in general, oftentimes without their consent, and children as well, is that if there is a positive toxicology, then this will lead to somewhat differing approaches to how these women were treated, right? So for Black and Brown women, largely what we see is that it leads to an investigation by the Department of Social Services, not actual aid or help or any sort of resources. And then largely for white women, they are treated as a substance use disorder and given medical treatment accordingly. Why is this important? It's important because, like I just said, almost 40 to 50% of those removals that took place in the state of Virginia were of children under the age of 1, meaning that this is in line with my observations in practice that women were having their babies removed from them in the hospital for testing positive for substances. And you might say, well, what substances? It doesn't matter. Largely, a lot of those substances were marijuana, right? And sometimes it was other things, right? Sometimes it could be an opioid or something else, but essentially none of that had anything to do largely with the actual harm that was perceived to occur to the child if the child were to go home with the mother, but largely as it relates to what had taken place in terms of the positive toxicology. Okay, and so the reason why we know this is important to discuss is we think about the term family disintegration, and really what we're talking about here is sort of how state intervention through criminal system, through the family regulation system, leads to breakup of the family, distrust, separation, permanent separation through termination, which can lead to community disintegration, right? A lack of support networks that are naturally occurring within the community to help families be able to stay together safely. And then that leads to generational recidivism and dependency on the same state actors who have disrupted their family. So what does this look like, right? You increase family disruption, supervision, and policing through the criminal legal system, but also through mandated reporters, the child welfare system, and you focus on specific neighborhoods and groups, right? This causes a high number of cases to be called. We know that these cases don't always have to result in court intervention. We know that these cases can just result in sort of what we call indicated cases. When that takes place, that reduces the number of people who are allowed to then become caretakers or supports for people who might become involved with the system in the family. So now the children are going to be placed in foster care as opposed to being placed with relatives. That placement in foster care increases the likelihood that the family will be permanently separated. And so this also removes cultural autonomy. It replaces caretaking with surveillance, and it enables the feeling of powerlessness. Increasing resilience and dependency on state and institutional providers, such as child welfare agencies to provide support, as opposed to families to provide support and communities to provide support. This is creating that pipeline of sort of child welfare to prison, child welfare to generational involvement. We know that in 20 years since the passage of the ASPA, that there has been over 1 million adoptions. We know that now the question is there a better outlook given the sort of way in which criminal legislation has sought to improve the way in which we are addressing substance use, right? We know that, and I think the easiest way to think about this is from the perspective of thinking about marijuana justice. Over the past few years, there has been so much work done on the ground by organizations to get legislation passed to decriminalize the use of marijuana. right? We know that states have been successful. We're looking at the state of Virginia. We also can think about the state of New York, right? But I want to talk to you about what that success looked like in terms of family regulation. The process and the progress is slow. In New York, while I was there litigating, even after there had been sort of this idea of decriminalization, I would say even beforehand, before decriminalization, right? Because of all the effort that was put into the campaign to decriminalize, state courts started to say, hey, listen, ACS, you shouldn't be removing kids solely for marijuana. And I will say that, I think the agencies there said there was a lot of pushback from child advocates. There were a lot of pushback from parent advocates that said we shouldn't be removing kids solely for this. But what that unintentionally does is push a harder focus into other substances, right? So yeah, maybe we shouldn't remove just for marijuana use, but cocaine, heroin, these other substances became like, well, this isn't just marijuana. It's not as easy as marijuana, right? And so I think one of the things that sort of is maybe an unintended consequence of really focusing on one particular substance as like not harmful as opposed to other substances is that the consequence that those families who are subjects of those sort of substance use disorders become more harshly sort of supervised and surveilled. And then I think the other sort of consequence of that is that that sort of law and rule was not always applied unanimously and across all groups of people the same way. Now, in the state of Virginia, one of the things that I've been able to see since the very recent decriminalization of marijuana use, right? It's just thinking about observations in family court. Over the summer, I observed several times where, and I think I was told this actually, that generally when people come in for test for their child welfare cases, even if substance use was not a part of their original allegations or reasons for maltreatment, it could be a parent could be subject to test it, or a child could be subject to test it, right? And so if there was a positive toxicology, and I actually observed this one time, the positive toxicology for marijuana was used as a basis for not allowing unsupervised visits. In addition, there was a discrepancy shown where there was a parent who was, I believe, on probation and or parole, and a part of, even though marijuana has been legalized, the probation report came back as a positive toxicology for marijuana, which became an issue in the child welfare case, right? In terms of trying to establish custody for that parent. And so what we know is that even though this legislation is taking place in the criminal court, without also making sure that those changes are equally absorbed in other areas such as the civil law and in sort of these other institutions of surveillance such as probation and parole, the protections don't extend, right? And so therefore families are largely being left out to dry, even though they may be complying with the law as it is written criminally in the criminal code. So then the question is, where do we go from here? Are there any sort of solutions? Are there any ways in which we can think about how we change the narrative and do this differently? I believe so. I think that it's on us to reimagine, rebuild, and think about how we can support substance using parents, and thinking about the narrative that we create for how this is treated differently in the criminal system as opposed to the civil and child regulation system. So long term, I'm a proponent of dismantling the child welfare system altogether. As I have largely talked about throughout this presentation, a system that was created for the protection of children and families has largely done just the opposite of that, right? And now we find ourselves grappling with the long-term harms that have been caused, right? And the question is, can we repair those harms? Is there a way for us to do that? I don't know how you can repair terminations, right? I don't know how you can repair over 1 million adoptions. And it's not to suggest that some of those children aren't in healthy, loving homes, right? But what we know is that many of those children, and we know that over 50% of those children who are rights are terminated, parents' rights are terminated, and who are adopted are infants, right? Often when those children become teenagers, the data suggests that those children become broken adoptees, right? What we call as families where the teenagers now are experiencing behavioral issues or some other sort of developmental issues, and then the adoptive parents are able to place those children back in the foster care system, or otherwise the children run away. There's something that happens that creates a broken adoption. They have little contact or connection with their biological families. And I often would see in New York, those same, where there was contact still in place, a lot of those children returning back to their biological families and trying to put the pieces together from there. So I think the best long-term solution is figuring out to how to dismantle this system and give power back to the communities that have been harmed in terms of how to regulate, provide, and nurture and support themselves, right? But in the short term, I think that we can address this by thinking about how do we change the narrative. Obviously, I think if we can adopt some holistic defense techniques that allow us to consider both the civil and criminal implications of the family regulation and separation system, I think that is the defender officers in New York have shown that takes great strides in improving the outcomes for children and parents involved in the system. I think the second thing that we can do pretty quickly is change the narrative as to what is neglect and abuse. Look at the codes, the code in Virginia, the code in other states, as to what amounts to neglect. I showed you guys some ideas here about exactly how substance use is treated. We can think about how the code reflects this, and we can specifically change that. We can change the narrative as it relates to how we treat substance using parents, from one that is punitive to one that provides for treatment. And when we're talking about treatment, I think we also have to change the narrative as to what we consider treatment, right? Very much, I have met with several treatment providers in the state of Virginia, and they consider themselves to be zero tolerance treatment providers, right? Adopting a harm reduction perspective to substance use provides for great outcomes. The data is very supportive that this is a great way in which we can help people, provide actual aid to people that need it, who are substance addicted, but also ensure that families are able to safely remain together through safety planning and providing for the actual needs that they have, which leads me to my next point: providing for meaningful economic justice and basic necessities to reduce poverty-based neglect. Oftentimes, what we find for parents who are accused of abuse and neglect based off of substance use is that they are living in poverty. They do not have access to basic mental health, medical needs. They don't have access to safe and affordable housing. And so oftentimes, as they are one in their own recovery of substance use, they're separated from their child, right? And so one of the things that we can advocate for is improving the facilities and organizations and resources that are available to provide for affordable and safe housing, and then community resources that are separate and apart from state ordained services like or operated services like the Department of Social Services. One of the things that oftentimes comes up when you're having this conversation is, oh, well, what about trauma informed? If it's trauma informed, we can provide relief, we can provide funding. But what I would challenge you to think about is, why does it need to be trauma informed? When we're using a culturally competent lens to look at these issues, what we know is that a lot of the substance use that is taking place is within different specific communities, right? And how it is handled within those communities varies very differently depending on whether that community is largely Black, brown, or white. And so focusing more so on advocating for the divestment of funds from state operated prevention services that do not use the same culturally competent lens, and does not invest in the structure and support systems that are already in place in the community. I think moving from that model to one that focuses on community-based resources would also help to change the narrative in terms of how parents who are substance addicted are treated in the child regulation system. So at this point, I will open up for any questions and comments. Feel free to ask away. Thank you.